Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Peter, nice to see you again.
You too, Trevor.
A crisp autumn morning or afternoon, rather, in Cape Town.
Indeed.
It's actually freezing where I am. Mercifully, the sun is shining. Yeah, so we gathered once more for a podcast, and I sincerely hope that our viewers and or listeners enjoy these podcasts even half as much as I enjoy doing them with you, Peter. Guys, it's nothing but fun.
Absolutely.
Okay, so what I wanted to talk about today was a case that is not a new case, but it strikes me that the message hasn't quite got through in certain quarters. And of course, what I'm referring to is the South African Revenue Service. And that the case is Warner Lambert, South Africa Pty Limited versus SARS. And it was reported in 2003. And the judge who gave the judgment was Conradi J.A. And he was for many years Conradi J in Cape Town. And if the truth be told, I think I can say I had a sort of a love-hate relationship with Conradi J, and it was probably entirely reciprocated. He used to give me a hard time, but we there was a good deal of goodwill underneath it all. And when he went to Bloemfontein, especially if I wasn't appearing in front of him, I would often take him up a book or something, and so we'd see each other otherwise than on the bench, and it was good fun. Anyway, so this I think is a brilliant judgment of Judge Conradi, and in fact it ran somewhat counter to something I'd argued in front of him previously when he was in the tax court in Cape Town. But the reason I think is that when he was in the Supreme Court of Appeal and the Constitutional Court, well, it probably did exist then in 2003, but certainly not for tax matters. He felt he was now at large to take on board some overseas precedent, which he hadn't felt free to do when he was what they call a puisne judge, spelled Puisne, which means a judge of first instance. Okay, so the Warner Lambert case, let me read from the very first paragraph of Conradi's judgment, because he has an excellent turn of phrase, and he has a way of putting things. He said the following in paragraph 1 of his judgment. Reverend Sullivan was an anti-apartheid activist. He became known for his Sullivan principles. There were 7 of them. They were assembled into a code intended to govern the conduct of their business by American companies trading in apartheid South Africa. One realizes with the bewilderment of hindsight, isn't that a lovely phrase?
Yeah.
That they were at the time considered by many South Africans to be revolutionary. They were actually sensible, and most American companies operating in this country adopted them. The appellant was one of these companies. It joined an associate of local signatories to the Sullivan Code in Cape Town in 1978 and became an enthusiastic participant. Its senior management devoted much time to what were called social responsibility projects that eventually consumed amounts dictated by the Sullivan Code, equivalent to 12% of the appellant's payroll. All in all, the appellant was a model of compliance. Each year when its performance was assessed in the United States, it attained a mark of 1, which was the highest it could get. And, I was in that case, and I know that, the American directors of the American parent company could be arrested and face imprisonment if they didn't comply with the Sullivan Code principles. And later on, there was the Comprehensive Anti-Apartheid Act, and et cetera, et cetera. So the dispute was whether Warner Lambert was entitled to claim its so-called social responsibility or Sullivan Code expenditure in terms of the general deduction formula. SARS initially disallowed it on the basis that it was not in the production of the company's income. When the matter got to the tax court, they widened their attack as well and said it was also not for the purpose of trade and was of a capital nature. And it came in front of our co-editor Davis J in the Cape Tax Court, and he held, assuming that it was in the production of income, that it was indeed of a capital nature. And so that's what the court below had held, and then Davis granted leave to appeal to the appeal court. In paragraph 5 of his judgment, Judge Conradi was a little bit more expansive. He said the appellant's case is that it was instructed by its United States parent, a pharmaceutical company listed on Wall Street, to incur the expenses that went with the performance of its Sullivan Code obligations. The company has now changed its name and it's now Pfizer. Compliance was of such importance to the foreign directors that there was a possibility of disagreeable consequences for the appellant if it failed sufficiently to exert itself in this field. To save itself from political embarrassment and to protect its own business in the United States, the American parent might either close down the business, as Kodak had done, or sell the appellant's concern to somebody else, as Mobil Oil did. If this had happened and the appellant was no longer a subsidiary, it might not have had access to its raw materials, trading stock, know-how, and technology, which would impede its domestic growth, and it would be hamstrung in expanding into the rest of Africa, from which the parent company was withdrawing. In short, the appellant would almost certainly have suffered a loss of income. So that was the importance of this, and that was why they did it. Then getting more to what was in issue, and I think I'm going to quote fairly extensively from the judgment because the stuff is good and Conradi puts things so nicely. Dealing with Section 23G, wholly and exclusively for the purpose of trade, and nowadays after the amendment subsequent to the solar glass cases, just to the extent you can deduct expenditure to the extent that it's incurred for the purpose of trade. On this subject, Conradi said the following: "It is quite easy to mistake the purpose of an act for its consequences. This may have been what happened in ITC 1706, but it is difficult to tell since the evidence was, of course, different." That was a judgment in which Judge Wunsch had held that Sullivan Code expenditure was not deductible. But it seemed to be a different basis. Botha J.A. emphasized the point when he said in the solar glass case, and he then quotes Botha to say the following: "The truth is, in my judgment, that there are no hard and fast rules for deciding whether a taxpayer's expenditure falls within or outside the ambit of Section 23G. It is not possible to devise any precise universal test for determining whether expenditure comprises monies exclusively laid out and expended for the purposes of trade. In general, one can say no more than that the issue is to be resolved by examining the particular facts of each individual case," which of course doesn't help us terribly much. Conradi continued as follows. He said, the consequences of an act often proclaim its purpose. After all, a person is presumed to have intended the natural consequences of his acts. Nevertheless, the court must look carefully at the evidence. If there is credible evidence about a taxpayer's purpose, it is not open to the court to turn what is in reality a consequence into a purpose and ascribe that to the taxpayer. He then quotes from Smallberger in the Pick and Pay Employee Share Purchase Trust case, where Smallberger J.A. said the following: "In a tax case, one is not concerned with what possibilities, apart from his actual purpose, the taxpayer foresaw and with which he reconciled himself. One is solely concerned with his object, his aim, his actual purpose." And then Conradi continues, as Lord Brightman explains in a passage from Malalieu's case, it's a case of Malalieu versus Drummond, quote, an expenditure may be made exclusively to serve the purposes of the business, but it may have a private advantage, end of quote. Again, quoting from Conradi, the evidence for the appellant is to the effect that the purpose of the Sullivan Code expenditure, all the Sullivan Code expenditure, not merely the social responsibility expenditure, was to insure against the risk of losing its treasured subsidiary status. And one should perhaps state that some of the expenditure was allowed by SARS and others was refused. Conradi then says, if therefore the purpose of the admittedly deductible expenditure and that of the contested expenditure was the same, their tax treatment should also be the same. Both were expended in the production of income, or neither was. It is true that the link between the appellant's trade and the social responsibility expenditure is not as close and obvious in the second category as in the first, but that does not mean that the connection is too remote. To qualify as monies expended in the course of trade, an outlier does not itself have to produce a profit, and he then quotes from Judge Corbett in the De Beers Holdings case, one of the leading cases on 23G, where Judge Corbett said the following: it is true, as I have already indicated, that the absence of a profit does not necessarily exclude a transaction from being part of the taxpayer's trade, and correspondingly monies laid out in a non-profitable transaction may nevertheless be wholly or exclusively expended for the purpose of trade within the terms of Section 23G. Such monies may well be dispersed on grounds of commercial expediency or in order indirectly to facilitate the carrying on of the taxpayer's trade. Well, there was certainly commercial expediency involved in Sullivan Code expenditure. Conradi J.A. continues as follows. A loss of the appellant's subsidiary status might have directly brought about the loss of all kinds of trade advantages. It was unthinkable that the appellant should not comply with the Sullivan Code at all. It was not certain what would become of it if it complied, but failed to do so adequately. But the appellant was not obliged, and if the truth be told, would not have been permitted to take the risk of finding out. The Sullivan Code's expenses were bona fide incurred for the performance of the appellant's income-producing operation and formed part of the cost of performing it. The social responsibility expenditure was therefore incurred for the purposes of trade and for no other. So he held that the company passed the trade test in Section 23G. Then he turned to the question of whether the expenditure was of a capital nature, and this is really why I wanted to why we're discussing this case. As I mentioned, the tax court had disallowed the expenditure on the basis that it was of a capital nature. Conradi J. said the following, and you see here the way in which judges, when they want to depart from previous authority, they do so in an ever so subtle way, but it's lovely to read. The social responsibility expenses incurred by the appellant were seen by the court arquo as a capital expenditure. Its counsel submitted correctly that there was no question here of the creation or improvement of a capital asset in the hands of the appellant. That is not conclusive, for as Ogilby Thompson pointed out in the KDAC case, quote, the mere circumstance that a taxpayer has neither created a new asset nor made an addition to an existing asset is not necessarily conclusive in favor of such payment being a revenue expense. Then Conradi continues admirably as follows. I agree that it may not be conclusive, but it is a consideration of considerable importance in assessing, on the one hand, the closeness of the connection between the expenditure and the income-earning operations, he's referring to what Schreiner said in Gen's case, and on the other hand, whether there's a relation between the expenditure and capital close enough to draw the expenditure into the ambit of capital, which is what Stain CJ said in Smith's case. Where no new asset for the enduring benefit of the trade operation has been created, any questioned expenditure naturally tends to assume more of a revenue character. And now we come to the crunch. Conradi J.A. held as follows. He said, the appellant's income earning structure had been erected long ago. It was now a question of protecting its earnings. Periodic payments were required to preserve it from harm, or at least to avert the risk of harm. I regard these payments as similar to insurance premiums. If they are anything like that, they were payments of a revenue nature. There's support for this in England, and he refers to Morgan versus Tate and Lyle, where it was held that the expenditure incurred in a propaganda campaign against nationalizing the sugar industry was of a revenue nature. And then he refers to Lawson versus Johnson Matthey, a payment by the appellant to avert a threat to its business due to the collapse of a banking subsidiary. And that was held to be of a revenue nature. So as a result, Conradi held that it was not of a capital nature, and the appeal was successful. And to me, the most refreshing and innovative aspect of Conradi J.A.'s judgment in Warner Lambert is the finding that expenditure incurred in order to protect or preserve an income earning structure, in other words, a capital asset, is expenditure of a revenue nature. This was put as follows by Lord Templeman in Johnson Matthey, and I quote, if, on the other hand, the £50 million were paid to remove the threat posed by the insolvency of JMB, Johnson Matthey Bank, to the continuation in business of the taxpayer company, it seems that the payment is attributable to revenue. And in one of the standard textbooks on UK tax, and known as Tiley and Collison's UK Tax Guide, the principle is stated as follows, just in one simple sentence. Sums paid in order to preserve the capital or capital assets of the business are revenue expenses. So it seems to me that prior to Warner Lambert, the orthodox South African view would have been that expenditure incurred in order to preserve capital or capital assets would be regarded as expenditure of a capital nature because of its association with the capital or capital assets of the taxpayer. And that was more or less what was held in the KDAC case. But in Warner Lambert, which was a unanimous judgment of the Supreme Court of Appeal, they opted instead for the approach embodied in the Johnson Matthey case, that expenditure incurred in order to preserve the capital or capital assets of a business is expenditure of a revenue nature, notwithstanding the fact that it is a capital asset that is being protected. Another way of saying the same thing is that expenditure incurred to protect or preserve the taxpayer's income earning structure is expenditure of a revenue nature. And in the Johnson Matthey case, there were 5 judges, and Lord Keith of Kinkle expressed himself as follows in a very short concurring judgment. And he said the following, a number of decided cases make it clear that a payment to get rid of an obstacle to successful trading is a revenue and not a capital payment. I refer in particular to Mitchell versus B.W. Noble Limited, Anglo-Persian Oil versus Dale, and Inland Revenue Commissioners versus Caron Company. This, and here's the point, this must be no less true of a payment made to save the whole of an existing business from collapse. So the importance to me of the Warner Lambert case is essentially the South African Supreme Court of Appeal accepted what was trite law in the UK, namely that where you incur an expense to protect or to preserve a capital asset, that is revenue expenditure. And that, to me, that was accepting new law. And if one looks at business today, where companies are forced to do things in order to get BEE points and et cetera, these principles must surely apply as well.
And that's such an interesting, sorry, Trevor.
Yeah, no, so let's not forget Warner Lambert. That's all I'm saying.
I was going to say, such an interesting part of law that we practice in, where cases that were heard, 20 years ago, longer than that, are still as relevant today as they were then.
Yeah.
And how, as you say, on small little nuances, a judge can go a different way from a judge a quo. And the world of subtle nuances is very important in tax law, I think, Trevor, especially when you come to the general deduction formula, where you have to comply with all the various requirements. And I was just thinking when I was listening to you, we should also have a podcast on production of income in the context of dividends, interdependence between, or interaction between dividends and interest paid, where you borrow money to declare a dividend, because there's so much case law and they're all going different ways. And, again, another interesting part of the general deduction formula and the nuances, the important nuances that can turn a judgment in your favor or not. So really interesting. I'm going to talk about something completely different. I'm going to talk about quite a sort of technical aspect relating to dividends. And Trevor, we'll both remember when the dividend definition in Section 1 of the Income Tax Act was a very long and very complicated definition that referred to share premium and share capital and capitalized reserves and tainted share premium and wonderful days of practice where you could really sort of dig into the definition, and now it's disappointingly simple, and it just really talks about an amount that's distributed in relation to a shareholder. And that was in line with the changes to the Companies Act, because the Company Act also, kind of was simplified, if you like, and refers to distributions, and the concepts of sort of share capital and share premium have now been done away with. So from a tax perspective, essentially a dividend is a distribution to a shareholder that doesn't reduce contributed tax capital. So I don't oversimplify it, but when there's a distribution on a share, you can almost elect whether it's a dividend or not. If it doesn't reduce contributed tax capital, then it simply becomes a dividend. So when a dividend accrues, as we all know, when it is declared, it accrues to the shareholder. And in the case of a listed company, it accrues on the record date, the old LDR date. And if it's not a cash dividend, so if it's only paid later, then it's outstanding. It remains outstanding as a claim. And people often refer to that as a dividend declared on loan account, which is, your legal nerves kind of jangle a bit because it's not a loan. There's no amount advanced. But colloquially, it's sort of outstanding on loan account. I'm going to rather use the word outstanding as a dividend claim. And then when it's subsequently paid, this obviously is the receipt of an earlier accrual for income tax purposes, and no tax consequences there. So then now we turn to capital gains tax. If the dividend is not a cash dividend and it's outstanding as a dividend claim, then the shareholder has a claim for payment. And in my view, that is an asset from a capital gains tax perspective, similar to if it was a loan. The shareholder can claim payment against the company, and there's a very wide definition of asset. The next question from a CGT perspective is, does the shareholder have a base cost in this asset, this dividend claim? Did it incur any expenditure in order to acquire this dividend claim? And I don't think it did, because the shareholder doesn't do anything to obtain the dividend. It doesn't give up any rights. It receives it qua, I love that word, qua shareholder, as a consequence of its bundle of rights comprising the shares. So there's no expenditure in relation to this dividend claim. So what happens when the company pays the shareholder from a capital gains tax perspective? In order to avoid double tax between capital gains tax and income tax, there's certain provisions, in paragraph 35 of the 8th schedule applies. It's what it basically says is your proceeds from a capital gains tax perspective are reduced by any amount that must be or that was included in the gross income of the person. So here, as I said at the beginning, the dividend was included in the gross income of the person. So the proceeds, when the dividend claim is paid, the proceeds from a capital gains tax perspective are reduced to zero. So that's all fine. That all makes sense. No expenditure, no proceeds, no double tax, all good. But what happens if the shareholder transfers its dividend claim to a third party, or if it distributes that dividend claim up to its shareholder? In the example where it transfers that dividend claim to someone else, it now transfers an asset in respect of which it doesn't have base cost, and it receives proceeds, being the purchase price, the sale price of that dividend claim from the third party. And that now, paragraph 35, does not apply because it receives a different amount from a different party, not the amount that was included in its gross income. It's not receiving its earlier accrual because it's getting paid for the sale of that dividend claim from the third party. So if that's the case, then there's capital gains tax with no base cost. So you kind of think, but that can't be right. And if it's not right, then how do you resolve it from a legal perspective? What's kind of missing here? What are we missing here? And
Can I just interrupt? Can I just interrupt
yeah, of
you?
course.
Calls to mind that quote from I forget which judge it was. The judge who said, "My legal nerves may be weak, but I confess that this comes as something of a shock to them." Carry on.
That's the phrase I was looking for. So quite funny. So SARS has provided a couple of rulings on this, and there's also it's in its guide, CGT guide. It sort of turns itself inside out in order to provide a solution. And I'm not going to go through those rulings and that CGT guide rationale for why this isn't a problem, because effectively SARS creates a base cost in this dividend claim, which I'm not sure is there to be, to cut through it. So it tries to get rid of the problem by creating a base cost. So when the shareholder does sell this dividend claim, proceeds equal expenditure. But as I say, my legal nerves also get a bit weak when I see that reasoning. And it's obviously trying to solve for a problem, a tax problem that shouldn't be there. You should not have capital gains tax when you transfer a dividend claim or when you distribute it. But it often arises in the context of intergroup transactions because companies declare dividends, they leave them outstanding on loan account, and then years go past and then they just reflect it as a loan in their accounts. And then when you're doing a restructure, you kind of want to get rid of it. So you distribute it up to the shareholder or you transfer it to another company against payment. So just to warn everyone that this is an issue. I don't think it's just an academic issue. I think it's a real legal issue. And SARS seems to have a lot of sympathy for the taxpayer in these situations. As I say, there have been some rulings, you can't rely on them, but there have been some rulings, and there is the CGT guide, which again, you can't rely on, but it is there. He's sort of implying that these kind of transactions, won't be taxed, but just to bring everyone's attention to them because they arise a lot. And it's, again, another example, Trevor, of how sort of interesting our field is, where you sort of, the legal nuance of kind of what you're doing, and the fact that a tax doesn't always make sense. There sometimes is not a logic in tax when you're sort of when you read very technical provisions, and in particular the interaction between capital gains tax and income tax. So just kind of a general caveat and warning to everyone around something that we see quite a lot of in practice.
Yeah, that reminds me of what Eddie Bromberg said in his fantastic book Tax Strategy. He said that there's a Kafka-like unreality about the tax system, although the consequences if they go against you are all too real.
That's absolutely right. And if you think about this case where you've basically got a dividend which is exempt, and we all know that's exempt, that's kind of trite law, and then suddenly you're faced with a capital gains tax bill on the whole amount. Just seems like it cannot be right. So again, you feel like, when you read something, you read language, context, and purpose into many. But as we started off this podcast, Trevor, judges can find in different ways depending on the facts of the case and the nuance of the case, and it depends how they read the particular legislation. And to me, if you read the law, this is an issue, and it would be very nice if it was dealt with in statute as opposed to us having to reason out answers. But so far, that hasn't happened.
Yeah. So caveat, taxpayer.
Yeah.
No doubt you've got some
Absolutely.
cunning moves to obviate those sorts of problems.
And what we tell clients is just be careful. And if you have a dividend claim that's outstanding, make sure it gets paid, or make sure it gets capitalized, and before you do any sale or before you do any restructure. So just have a very careful look at your low, inverted commas, loan accounts that you have between companies, and where necessary, capitalize or pay them before you do any restructures, so you avoid this kind of problem. So yeah, practical advice.
Yeah, it's tempting to just say that when a good dose of common sense needs to be applied, and that capital gains tax should be confined to capital assets. But we all know that doesn't work like that,
Absolutely. And that is part of the thing, because we don't have a separate capital gains tax regime. It's just capital gains are brought into taxable income in terms of Section 26, Capital A of the Income Tax Act. So it all sits together. And then you rely on this sort of, bit in the capital gains tax provisions that reduce proceeds and reduce expenditure in circumstances where the Income Tax Act is applied, but it's not perfect. It's not a perfectly symmetrical system. So it makes our life interesting, Trevor. We shouldn't complain as tax lawyers.
Yes, but when one's heart goes out to the taxpayers, we might get caught up in something like this.
Absolutely,
Go
yeah.
for their own, because one just doesn't think about it.
Yeah, you just don't think about it. Absolutely. Yeah. So yeah, interesting what to leave everyone with, but nice chatting as always, Trevor. And yeah, look forward to our next one in the not too distant future.
Yeah, we keep up the pace.
Absolutely. Yeah. Lots of interesting topics.
Yeah.
Thanks, Trevor. Until next time.
Oh, thanks very much.
Cheers.
Bye-bye.
Bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dax. For more information on our journal and other products, please visit our website at Taxpayer.Co.Za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at Taxpayer.Co.Za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.